When you're facing a lawsuit for breach of contract, your best defense might actually be a good offense. A counterclaim allows you to turn the tables on your accuser and assert your own claims against them. A counterclaim for breach of contract is a legal response used by defendants to not only defend themselves, but also to make their own allegations against the plaintiff. In essence, it's saying, not only did I not breach our contract, but you did. There are two main types of counterclaims. Compulsory counterclaims arise from the same transaction or occurrence as the original claim. For example, if business A sues business B for failing to deliver goods, business B might counterclaim that business A never paid the required deposit. If you don't raise these compulsory counterclaims during the original lawsuit, you lose the right to sue on them later. Permissive counterclaims, on the other hand, involve matters unrelated to the plaintiff's claims. These allow parties to resolve all their disputes in a single lawsuit, even if the issues aren't connected. Courts typically address related claims together, but may handle unrelated counterclaims separately. When defending against a breach of contract claim, you have several tactical options. Some defendants use delay as a strategy, either to frustrate the plaintiff or to buy time to gather funds. This might involve denying receipt of claims forms or appealing default judgments. However, this approach carries significant risk, as courts have become stricter about non-compliance with procedures. Another tactical defense involves claiming that the contract was modified after signing or through verbal agreements. Since these claims often require oral evidence, they can't be fully addressed until trial, potentially delaying proceedings for months. But if you can't prove your claims at trial, this strategy could become very costly. Settlement offers represent another tactical approach. Even when a breach is clear, the exact amount of damages might not be. If you offer to settle for less than what the plaintiff is claiming, they may feel pressured to accept, especially since rejecting a reasonable offer could lead to them paying both parties' legal costs if the court awards less than your offer. Beyond tactical maneuvers, defendants can assert affirmative defenses. These introduce new facts that, if proven, negate liability even if the breach occurred. Common affirmative defenses include fraud or misrepresentation, where you claim the contract was induced by false statements. Duress or undue influence can be claimed if you were coerced into signing. Lack of capacity applies when a party legally couldn't enter the contract, such as minors or mentally incapacitated individuals. Other affirmative defenses include mutual or unilateral mistake about basic contract terms, illegality if the contract involves unlawful activities, and unconscionability when contracts are extremely unfair due to imbalanced bargaining power. The statute of frauds requires certain contracts to be in writing, making oral agreements potentially unenforceable. Estoppel prevents plaintiffs from enforcing terms they previously waived, while impossibility or impracticability can excuse non-performance when unforeseen circumstances make it impossible or unreasonably difficult. In industries like construction and commercial development, counterclaims are especially common due to the complex, multi-party nature of projects. If a general contractor sues a subcontractor for delays, the subcontractor might counterclaim that the delay resulted from the general contractor's failure to provide site access or materials on time. Typical counterclaims in these industries include non-payment for completed work, delays caused by the other party, poor project management, negligent design, misrepresentation of project scope, and breach of implied warranties. A successful counterclaim not only defends against the lawsuit, but may result in recovering damages. An important legal strategy is arguing in the alternative, which allows defendants to assert multiple defenses, even if they seem contradictory. For instance, you might argue that the contract is invalid due to fraud, but alternatively, that you fully performed your obligations, or if you did breach, that the plaintiff exaggerated the damages. Courts understand these aren't admissions of guilt, but legal strategies covering all possibilities. Timing and procedure are critical when making counterclaims. Under federal rules, compulsory counterclaims must be filed in the same proceeding if they arise from the same transaction. Failing to do so means losing the right to bring that claim later. File your counterclaim promptly, typically at the same time as your answer to the original complaint. Gather supporting documentation like contracts, communications, and evidence of performance. Be aware of jurisdictional rules, as state courts may handle counterclaims differently. Understanding counterclaims for breach of contract provides powerful tools for defendants. They allow you to shift from a purely defensive position to asserting your own rights and claims. However, the complexity of contract law means that proper legal guidance is essential to navigate these waters successfully and protect your interests.